The spy tape saga is far from over. The National Prosecuting Authority is now approaching the Constitutional Court directly to appeal an earlier ruling. It follows a statement by President Jacob Zuma, who says he's still mulling over a recent judgment on the controversial issue. Now, in April, the High Court ruled that the NPA had been irrational when it withdrew charges against Zuma for his role in the arms deal. Last month, the same court dismissed the president's and NPA's application for leave to appeal. Now, the prosecuting authority says the matter raises constitutional issues, particularly on the separation of powers. For more on this story now, we're joined via Skype by eNCA legal reporter, and that's Karyn Maughan. Karyn, very good evening to you, and thank you very much for giving us your time. Firstly, what are the chances that the NPA will be successful at trying to appeal this at the Constitutional Court?
I think the big question, Goli, is really whether or not the Constitutional Court will hear them. On that score, I think they have a far better chance with the Constitutional Court than they would have had with the Supreme Court of Appeal, which we know has spoken quite profoundly on the issue of whether or not a decision not to prosecute can be reviewed. We know that in the Richard and Bluley matter, the court said very specifically that it could, and we know that the National Prosecuting Authority acted on the court's findings and did indeed reinstate both the murder and corruption prosecution against the former crime intelligence boss. Now, we know that in all likelihood that court would have denied the hearing of this matter, and now the NPA making, I would argue, quite a strategic decision in going to the Constitutional Court, because they still have a degree of wriggle room, if you can put it like that, to argue, well, the Constitutional Court hasn't pronounced on this issue. We believe our independence is being undermined, and we need the highest court in the land to make a clarification on this specific legal point.
Karyn, you've followed the case closely over the years. What do you think are the likely arguments that the NPA will advance at the Constitutional Court, if, of course, they are admitted?
I think they're going to argue what they've argued we've seen it from Shaun Abrams, that the NPA feels that what the Pretoria North Gauteng High Court did was essentially, to traverse, to overreach, as it were, to go within the ambit of, interfering with its powers, that the National Director of Public Prosecutions is the person best placed, as they will argue Mokatedi Mshe was at the time, to make a decision about whether or not a prosecution is so tainted by so-called political interference that it cannot proceed. As I said before, however, the big difficulty for them is that the Mbluli matter has already shown that a decision not to prosecute can be interfered with, as it were, by the court. The court ultimately, the DA, I think, will argue quite powerfully that any decision must be subjected to judicial review, and that the NPA cannot argue that it is above the law, which is effectively what it's trying to say here. They're going to say, any decision not to prosecute or to prosecute needs to be subjected to the same level of interrogation than any other decision by any other government body would be. And I think that is one of the big difficulties the NPA is going to have, is apart from the fact that the president is the person involved here, what makes this case different from any other ones? And I think that's going to be one of the big hurdles they have to face if they get into the Constitutional Court.
Karyn Maughan, the Constitutional Court being the highest court in the land, are we likely to see whatever decision that comes out of that court now, are we likely to see, in fact, is the country likely to see the end of this case?
Goli, I mean, this is really a question of, if the court decides not to hear this case, Shaun Abrams is going to have to make a decision. He either reinstates this prosecution or he withdraws it. But if he withdraws it, he knows that according to the decision made by the High Court, unless that is successfully overturned in the Constitutional Court, he will have to justify his reasons on a rational and legal basis. And the big problem for the National Prosecuting Authority and the big problem for the President is that the National Prosecuting Authority has never said that there was not a strong case for the president to answer. We know that there is detailed forensic investigation. We know the KPMG forensic audit showed over 5 million rand in so-called irregular payments to the president. We know from the Shabir Sheikh case that, it was proven under that case that Shabir Sheikh had indeed corrupted Jacob Zuma. And we know that the SCA and the Constitutional Court to some degree pronounced on that those findings stand in law. So the biggest difficulty here is that the Supreme Court of Appeal has already said that, it's not good enough just to say that there was political interference in the case. You have to show that interference was interference with the evidence. And that's not the case here. So, it's going to drag on. We know that, Kempe came for the president arguing very powerfully many years ago that they would approach what he used a Stalingrad approach to any litigation involving the prosecution of the president, fight them in every room, in every hall, in every house. We now see that exact same ethos coming into play with the National Prosecuting Authority, and it will be a very long road, whichever way it goes. But we expect fighting in every street, in every hall, in every house. And we don't expect there to be a prosecution of the president anytime soon.
All right. That was eNCA legal reporter Karyn Maughan, and it's certainly going to be the case to watch as the days and weeks go by. Thank you very much to Karyn Maughan.